So what about the non-Indian defendants? If it's an Indian versus a non-Indian, this becomes a somewhat open question. There's a case called Montana versus United States, and in Montana, which I'll talk about in a moment in more detail, Montana says that there's a presumption of tribal jurisdiction on Indian land. So that would include jurisdiction over the non-Indian defendant. But a lot of the commentary that you might read in this area raises some other questions. And I should point out that there's a case currently before the Supreme Court, Dollar General versus Mississippi Band of Choctaw Indians, that's likely to address this question, and probably an opinion that's going to come out very soon. But Montana versus U.S. Very explicitly says that this presumption exists. We'll see if the court decides to modify that. So on Indian lands, now we're going to look at non-Indian versus non-Indian when the dispute arises on Indian lands. And that is definitely going to go to state courts. State courts will definitely have jurisdiction there, but there's a possibility of concurrent tribal court jurisdiction. That's another gray area in the law. There's a case called Iowa Mutual versus LaPlante that has some very affirmative language in it, but a gray area of the law. So what about when the dispute arises on non-Indian lands within the reservation? And that's when the political identity of the defendant becomes very, very important. And I mentioned the Montana case a moment ago. And Montana versus United States dealt with regulatory authority, but subsequently the court said that it's going to apply to a tribe's civil adjudicatory authority as well. So Montana had this framework that it established to determine when the tribe is going to have jurisdiction over a non-member on non-Indian fee land. And the first thing that the court did was it examined the particular tribe's treaties, and also examined federal statutes to determine whether a treaty or a federal statute conferred civil jurisdiction on the tribe in this context. And it was only when it concluded that it did not that it moved to the tribe's inherent authority. So when you're looking at this type of a problem, you first want to look at treaties and statutes, see if there's civil authority in that area, then move to the tribe's inherent authority. And what Montana says is that off Indian lands, there's the presumption is reversed. So remember I said that on Indian lands there's this presumption of tribal authority, civil authority. If you go off Indian lands to non-Indian fee lands, that presumption is reversed. So there's a presumption against tribal authority on non-Indian fee lands. And that presumption can be overcome in one of two ways. First, if the dispute involves conduct that threatens or directly affects the health of the tribe's political integrity, economic security, or health and welfare. And the second way that it can be overcome is if the non-Indian consents to jurisdiction. So that happens every once in a while in contracts and things like that. But so presumption against tribal authority, civil authority on non-Indian fee lands, but the presumption can be overcome either by consent or conduct that threatens. And courts read those exceptions very narrowly. So when you look at Montana, you can see that there's this very questionable area of tribal authority over non-Indians on non-Indian fee lands, and you've got these different presumptions that are at work. And so that's why I said at the very beginning that the first step you want to take is identifying where the dispute arises and what the political identity of the parties are, because that's going to give you very different pathways in the analytical framework for figuring out whether the state or whether the tribe has jurisdiction. So to wrap up this discussion over civil adjudicatory jurisdiction, I want to make one other point here. What happens when a person is hailed into tribal court and wants to contest jurisdiction? How do they do that? Well, they first have to go through the process of tribal court first. So their tribal courts will be given the first, as a matter of comity, given the opportunity to determine their own scope of jurisdiction. And so then the defendant that wants to contest jurisdiction is going to have to go usually through the trial process and through the appellate process, contesting jurisdiction at the proper stages. And then if they're unhappy with that ultimate result that the tribal court comes to, then they can go into federal court and challenge jurisdiction. And so that's the what we call the exhaustion rule, that a person has to exhaust their tribal court remedies first before going into federal court to challenge state jurisdiction. So just in the last few minutes that we have, I want to touch very briefly on tribal regulatory jurisdiction. So we've been talking about adjudicating criminal matters, adjudicating civil disputes, and what's the scope of a tribe's regulatory jurisdiction in Indian country. And it goes back to that Montana framework, Montana versus United States framework that I discussed before. So to determine a tribe's inherent tribal regulatory authority, that Montana test is used. So there's a presumption of tribal regulatory authority on Indian lands, and then on non-Indian lands there's a presumption against tribal regulatory authority. And that can be overcome if it's conduct that threatens or you have the consent of a party. And as I said before, treaties can vest and recognize broader regulatory authority, so you want to make sure and take a look at that. And another aspect that's important in the regulatory context is delegated federal authority. So there's a number of statutes that delegate federal regulatory authority to tribes. And for example, environmental statutes like the Clean Air Act and Clean Water Act, there are provisions in there that allow federal authority to be delegated to tribes in much the same way that it's delegated to state governments when they meet certain criteria. And in Indian country, we've talked about that Congress has broad regulatory authority in Indian country pursuant to the Constitution, but there's a big open question as to whether this can be done through generally applicable laws. And for example, this is an issue that's being litigated right now with the National Labor Relations Act, and whether that law of general applicability can can be applied to tribes in their regulation of labor disputes and unions. So that's a big gray area, and those cases will be sort of making their way through the courts in the next couple of years. And then finally, when you're looking at regulatory authority, there's a preemption. And so there's a preemption of state regulatory authority within Indian country. No state authority over activity in Indian country if it's preempted by federal law. And this is a notion of preemption that's much broader than you may be familiar with in constitutional law. So state law will be preempted if it interferes or is incompatible with federal and tribal interests reflected in federal law, unless the state interests are sufficient to justify the assertion of state authority. So this is essentially a balancing of interests of the three sovereigns. But that's an important piece, state preemption of state regulation in this area.